Oh, there's no jury trial for contempt.
Well, on serious criminal contempt there is. But
You want to be careful. I just cautioned you about frivolous things. And this was the most frivolous thing in the case. All right, good morning. We're back on the record and recalling then copy Hope, file 24-9086CZ. Counsel, you want to state your appearances beginning with plaintiff's counsel?
Good morning, Your Honor. Alan Saltenhoff, Mr. and Mrs. Kopp. Apologize for my tardiness, Your Honor.
Your Honor, David Delaney appearing on behalf of Spencer Hope, who is standing to my left.
Okay, good morning to you both. All right, you can be seated. All right, so we've got a few things up today. It looks like we've got a continuation of a show cause for an alleged violation of the TRO. We have a motion for a preliminary injunction. The plaintiff, we have defendant's motion to dissolve the TRO. Seems like a lot of those issues kind of fit together and will require some testimony. We also have defendant's motion for summary disposition and plaintiff's response to that. So it seems to me that just procedurally what might make the most sense is to deal with the motion for summary disposition first, since that doesn't require testimony. So,
Your Honor, thank you. I would request several minutes of rebuttal if the court deems it necessary. Judge, this case is about 3 express recorded easements. What are the scope of those easements and are they overburdened? The defendant's motion for summary disposition seeks the court to require that all of the parties that are owners, either dominant or servient tenements of those easements, be joined in this action. Before I get to that, Judge, related to that, as the court indicated, first is the complaint that was filed in this case. The initial complaint, the original complaint, is defective. The numbering was skewed. There was half of a wherefore clause, and count 4 was almost omitted in its entirety. And I have filed pleadings, Judge, for many years. Mistakes happen. Things get misnumbered, commas get missed, and it's not where I'm going with that relief. It's just that the complaint itself had enough notable defects in it that there really should not have been any relief granted. The next and second issue, there's only 2, is in that original complaint, there is relief sought. And the relief is to...
Can I ask you, where are you going? Because there was an amended complaint, right? And you're asking for summary disposition of the amended complaint. If there's an amended complaint, the original complaint is superseded in its entirety, right?
Yeah, but not the TRO. The court would have to dissolve the TRO and
reissue. Well, that's a motion to dissolve the TRO. Right now,
correct.
I'm asking for argument on your motion for summary disposition, which would be of the amended complaint, right?
Okay, well,
so why do we care about what's in the original complaint?
Then that poses another problem for the plaintiff, because the amended complaint doesn't have any exhibits. So if it supersedes the original, now the court has no exhibits. And that's my point. There are 3 easements in this case, which is related to the motion for summary disposition. 3 distinct easements: Rudy Lane, Molokai Lane, and Adams Road. But even looking at the original complaint for a moment, you only had Rudy Lane. Yet the court granted a TRO relative to all of the land owned by the plaintiffs in this case. And quite frankly, all of the other owners, as we indicate in the site plan, that are subject to that. So you have 1 easement, but you granted a TRO based on 3. Then that intertwines with my motion, Judge. The quiet title action seeks to quiet title to the ingress and egress of the easement. How does the court grant that relief when it doesn't have the easements? I don't think the amended complaint had any exhibits. The copy I got did not. If that's the case, now you have a TRO based on no exhibits. And as the court indicated, I agree, these are all intertwined. The dissolution of the TRO is based upon the motion for summary because you don't have the proper exhibits. The TRO only binds the defendant. Why wouldn't it be reciprocal? Why wouldn't the court's order bind the plaintiffs and all of the other owners, and there's probably a dozen at least, but I haven't run the title, but I'm not the plaintiff in this case. The TRO, which is related to my motion, indicates that the only thing permissible is cars and non-commercial trucks for residential purposes.
Forgive me for a minute here.
Yes.
All right. I don't know what you're arguing. We're going to soon have arguments about whether to dissolve the TRO.
Correct.
Or to ripen it into a preliminary examination. We'll take testimony. We'll hear argument about if it should continue, what should be the scope of it. I thought your motion for summary disposition under C7, C8, C10 is to dismiss the complaint in its entirety.
Correct.
Yet you keep talking about the TRO.
Correct.
If this second I said TRO is dissolved, what then would you want me to do? So why don't we focus on that? Tell me what relief you want with regard to the action itself.
Order the plaintiff to join all parties benefited and burdened by the easements referenced in his complaint.
Okay, see, that's what was confusing me the very most about your motion, and I think what was the crux of Mr. Telgenov's response.
Sure.
That's a different motion, right? That's a motion for joinder.
That's correct.
That's not what you filed.
It says 2.205, which is a necessary joinder. I'll
Right,
cite
but
the
you didn't
courtroom.
file a 2.205 joinder motion, did you?
Well, it's not my job to join them. He has to join them. If he wants the relief in the complaint to quiet title to the easement, he must have
a motion for summary disposition, and now you're telling me the relief you want is not summary disposition, it's joinder.
Well,
So I'm really getting very turned around about the process here and what court rules. I'm looking at a motion for summary disposition. You filed.
that's correct.
Asking for summary disposition under C7, C8, and C10.
Correct.
Then I'm looking at a 1.5 page brief that makes no mention of C10.
Ouch. Did you hear that? The judge just called the defense's brief 1.5 pages and expressed extreme skepticism. In the legal world, having a judge call your work skimpy is a disaster. The defense is trying to use a summary disposition, which is a kill switch for a lawsuit, based on 1.5 pages of writing. The energy in the room just shifted. The plaintiff's attorney is sitting there probably smelling blood in the water. This is where the brevity defense usually starts to crumble.
Makes no argument about why it's barred by C7. And only says they haven't joined necessary parties.
Correct.
So, and then you want to reserve several minutes for rebuttal for a 1.5 page brief.
Well,
Count me really skeptical.
okay.
Why should I grant? I mean, you know what summary disposition is.
Correct. Correct.
That's a dismissal of the action.
That's right.
Is that what you're asking for today?
Yes. Because.
Tell me why.
Well, because, and I don't need a 25-page brief. I can make my point in 1 page. Brevity being the soul of all wit. In this case, if you look at his complaint, if you want to look at the amended complaint, he seeks to quiet title to 3 easements. He has no exhibits attached to his complaint. He has 1 owner attached, and I included a very detailed site plan for the court of all the owners that are affected by his complaint. How can the court grant any relief to the plaintiff when he has not joined the necessary parties, which is the argument I make. Now, whether he joins them is up to him, but he is not entitled under C9 to the relief because he lacks the parties. So his complaint is defective. It can be dismissed or he can join, but it must first be dismissed with the opportunity for him to join. So to the court's question, right to the point, he is not entitled to the relief he seeks based upon his complaint because he doesn't have all the necessary parties to do what? Count 3, quiet title to the interest of all the easements he references in his complaint. Drudy Lane, Molokai Lane, and Adams Road. How can he get that relief when those parties aren't here? And I cited as an unpublished case, the Savoy case is very similar to this, Judge. We went through this through a trial But every owner that had an interest in that easement, and there were 15 to 20 of them, were parties. That's my point.
Well, but except, look, the plaintiff is saying there's an easement, lots of people have a right to use the easement. Only one of them is overburdening that easement. And we want to restrain that person's overburdening use. Why are the other parties necessary parties?
Well, because the court's now granted a TRO saying there will be no public commercial use, and it's stated in the negative. It says cars and non-commercial trucks. He wants a preliminary injunction and ultimately a permanent injunction that there will not be non-commercial trucks on any of those 3 easements.
It would only be binding on Mr. Hope and his agents and assignments.
Why?
Huh?
Why would that be permissible? What about the
Why would
plaintiff?
it not be permissible? Explain to me why that would not be permissible.
The plaintiff, if you look at that Savoy case, and they cite published cases, they say you can't just restrict one easement owner. So in other words, the plaintiffs can have commercial trucks. They can get propane delivery. They can have mail delivered. They can, what if their well goes dry tomorrow? They can have a truck out there, and all the other owners. Why would Hope be subjected to it? Let me rephrase this. If the court's order said no contractor's yard, correct, I agree, I stipulate to that. He may not operate a contractor's yard on that road. Now that's more narrow, but this says non-commercial trucks. What does that mean? We don't know. We don't have definitions.
Okay, well, I mean, that kind of goes to the easement.
Right. Which, if I may,
What
Judge,
about that? I mean,
you determined that already. You've already said no commercial trucks, period.
Sure, well, I might be wrong. I signed an ex parte TRO, right? So that could entirely be wrong. We're going to hear some proof about that today. Maybe it's overbroad. Maybe we're going to narrow it. I don't know what I'm going to do today. I haven't heard a lick of testimony. I'm sitting here right now. I have no idea what's going to happen to that TRO at the end of this hearing.
Correct, Judge. May I just add one thing? Just because the court referenced testimony, and I brought witnesses today. This was set for yesterday. I understand that it got moved because of a courtroom is being repaired or something, but it moved to a Tuesday. My docket's already set in Gaylord on a Tuesday from 11 to 3. I'm on the court-appointed docket down there. We have a new judge. Those are all set in December. So I just want to tip the court off to that. I know you have a docket too.
Yeah, I have a docket too. So yeah, we're going to have some talk about that, whether we maybe need to set some special time.
Thank you. I didn't want to
We'll
blindside the judge. Thank you.
I have one more question for you about your summary disposition. There's also count 1 trespass, count 2 trespass, count 4 nuisance. Your motion doesn't seem to address those. It only deals with the easement.
Those are all premised on overburdening and exceeding the scope of the easement. And so once he establishes that, which the court did preliminarily and said no commercial trucks. So remember, we have 2 words, ingress and egress. What does that mean? And if the court had an opportunity to read that Savoy case, which is right nearby the site, that was Judge Allen years ago in Northern Gaylord, almost identical facts. The lower court and the Court of Appeals struggled to define ingress and egress. They said that it was blatantly ambiguous. But here, we've already right off the bat decided no commercial. And I didn't prevail on that case. The gas company got heavy commercial truck usage. In the end, the Court of Appeals ordered it. Now, what's the temporal limit? Not 2 a.m, not Saturdays, things like that. Even the final order of the Gaylord Court did not come up with a clear definition. But the well ran dry, so the case never got litigated beyond that. But back to the court's question. Those other counts are premised on a finding now that the easement is being overburdened. But you don't have those easements. You have none of them. If we're going to follow the amended complaint, so we have a TRO based upon no documents. That's why the nuisance claim would fail. That's the entirety of this thing. If I may come back to center. If we're litigating contractor yard, true. I will stipulate to that today. But we're not. We're out here. No commercial trucks. But only Spencer Hope, not the other 20 owners.
Well, we might end up, based on some of the things you said there, we might be in a position where we may be over litigating this, because I think if what you're saying is what is your client's intention, I think everybody would be happy with that. Mr. Telgenoff's nodding, and that would be only so far as I would really rule, is the intent of this case, as I understand it, is to prevent Mr. Hope from continuing to operate a contractor's yard in defiance of the zoning decision that was impacted by my previous ruling.
If he is.
If he even is.
Right, there's a presumption at the moment. I'm sorry.
They perceive that he in bad faith is continuing to do so.
Yes.
So maybe, setting aside a special day for us to take proofs with enough time where we can breathe is a good idea, that would give you guys time to talk some more. I can assure you, my intention in this case is really, or my perception, I guess, is that this case is about making sure that Mr. Hope doesn't continue to operate a contract.
That, Judge, we are in total agreement for the first time this morning, if I may, and the Planning Commission doesn't know either. They're waiting to hear from you, and it's all about this road. As you said, I wasn't here for your first hearing. I read the transcript, and you said it's really about the burden on the road. Once that gets decided, once you lay that out, and we address the issue of the contractor's yard, just for a quick example, he may go by with a commercial truck to a snowplow job. Well, he's now in violation of your order. I don't think that the court intended that. No contractor yard, we agree, I stipulate, even retroactively.
All right, thank you. Mr. Telgenoff.
Years ago, Judge, I had a case in Otsego, since we're talking about Otsego. I went in on a motion to compel discovery. And the other side, I thought it just kind of a throwaway in their prayer for relief, asked for summary disposition. Not only do we not want to turn over the discovery you asked for, you're not entitled to it, but the case should just be dismissed. And I didn't respond to it. I didn't take it seriously. I thought, you got to be kidding me. I'm going in on a motion to compel. Why would I be talking about summary disposition? The judge granted summary disposition under 2116I. When the pleadings make it clear that one party is entitled to judgment, the court shall enter judgment. And that's what the judge relied on. And that was quite a while ago. But what I took away from that is I was never going to take lightly a request for summary disposition. You could lose your whole case. And so despite the fact that counsel filed a 1.5-page brief that didn't have most of the things that he talked about today, I'll give you a few examples. He didn't bring up that there were 3 distinct easements and there are dozens of people. That's nowhere in his brief or in his motion. Didn't talk about the fact that, at least as he's saying today, and it sounds like he's not even sure, that the amended complaint didn't have exhibits attached. That's nowhere in the motion, nowhere in the brief. I guess that's probably enough. There's probably a dozen people, is what I heard counsel say, that need to be joined. That's nowhere in the brief. I took it seriously, and I know the court takes it seriously. Someone files a motion for summary disposition. In my opinion, it's the most important, most serious motion that comes before the court in a civil matter. I took it seriously. I briefed the issues. I researched the issues. I made the arguments. I stood here and listened to Mr. Delaney for however many minutes it's been, talk about this. And I don't ask for sanctions lightly. I think I learned years ago, courts get sick of every single case. Somebody asks for sanctions and whoever wins thinks the other person should pay their attorney fees. And I think you get a lot more, I hope, credit with the court when you only do that in a case that really calls for it. And it's hard to imagine a motion for summary disposition that calls for it more than here. I had to take this seriously. I had to research C7, which has absolutely no application to this case. I could see if there was a typo, I guess. I've been called out for typos. If he said under 2116C, grant summary disposition, and then we all had to guess, is it 1 through 10, which is, no, he specifically chose which numbers, and now I heard C9, if I heard that right. C7 has no application to this case. I had to take the time to research that, brief it. They didn't. All of what Mr. Delaney talked about, and I know the court, from your questions, I don't need to say this, but I will just for the record. All of what he was just talking about has nothing to do with the motion for summary disposition. Nothing. He cited the right rule, 2205. If he thinks that there's somebody that's mandatory joinder, they need to be joined, join them. Join them. File a motion. We've all done that. And we can argue that, whether it's permissive joinder, whether it's necessary joinder, we can have that argument. But when you do what they did, and then what I didn't hear Mr. Delaney addressing is the blatant misrepresentation of the courtroom. It's offensive. That was designed to leave the court, and I don't need to suck up to Your Honor. I knew that wasn't going to fool Your Honor. But to take out parts of it, to say that, oh, you can grant summary disposition in this type of a situation, when what the rule, when you look at the whole rule is talking about, is where the court doesn't have jurisdiction over these other parties, then what's the court to do? We said it's necessary joinder. This person lives in Ohio. We can't even get them served. What are we going to do? And then the court does have to weigh. Do I dismiss the case? How do I do it?
Do I understand your position correctly as I framed it in my questions to Mr. Delaney, that you don't need those other folks in the case because they're not overburdening the easement?
Right.
You want to restrain the overburdening of the easement.
Right. In just to be clear, the count 3, he talks about 3 easements. This Adams Road easement, it's the first time I've heard about this. I guess I need to go talk to Mr. and Mrs. Cobb. I know for certain it's not in the complaint. The prayer for relief says that my clients request that the court issue an order setting forth the rights of the parties hereto. I want the court to make a decision as to what are these parties' rights with respect to the easement commonly known as Broody Lane, and further enjoin them. We don't need the other people. I understand, and I take, counsel has made statements on the record that Savoy is on all fours and it's on point. That's great, because they held it was overburdening. That when you had a history of a place that was, out in the country, no one anticipated that we'd have a business there, and somebody puts in a commercial venture and is making commercial deliveries, that's overburdening. I'm glad to hear Mr. Delaney say he agrees that's on all fours with this case. That's great. That will make it go a lot quicker because they've acknowledged the overburdening. But what is different in Savoy, and I don't know that we need to talk about this for this, but just to respond real briefly, is Savoy, those people were operating the business legally. There was nothing in that case that I saw where there was even an allegation that oil and gas drilling wasn't allowed. It was in the easements. That was one of the arguments, was it was implied because they have oil and gas rights. Isn't it implied that they could remove it? There was no argument even that it was illegal business. That's what we have here. We have an unlawful business. That's what we will show when we do take proofs. And I'm tired of hearing about, today it was, if I took notes correctly, the Planning Commission doesn't know what to do with this. They're waiting to hear.
That's completely legally irrelevant.
And it's also untrue.
Well, even if they did,
I don't know if you've seen it yet. They're filing a complaint. They're filing an administrative complaint. Mr. Delaney, as an officer of the court, stood before Your Honor and said that, when I know for a fact the county's attorney called Mr. Delaney, told him it's coming, talked about accepting service, and yet he puts in the pleadings that they're okay with this. We're asking for sanctions, Your Honor. I shouldn't have had to file a brief on this. I shouldn't have to be here talking about this every minute that I've had to talk about this, and I had to listen to them talk about this. These poor folks are paying for it. And it's a game. This is a game. This idea that, and that's why I brought up some of the history in my response, because when you're looking at when do you give sanctions, and part of it is what's their purpose? And was this just a big screw up? I didn't hear that. Or was this, we had a court order that an answer was to be filed. This case is going to finally move forward. And instead of filing that answer, which is order, They file a motion for summary disposition. I'm not here to ask for a default and we can argue about all that. This is a delay tactic, just like when Mr. Delaney is emailing me yesterday saying, oh gosh, look at the court's docket. Let's push this. Let's push this. This needs to be done. It's costing these folks money. They've done absolutely nothing wrong. I'd ask that you deny the motion. I'd ask that you grant sanctions, Your Honor. And I can submit a bill of costs as well.
Thank you, Judge. So, now we're again, not here to solve the problem. Just here to make personal attacks, requests for sanctions. Let's look at his first complaint, which has now been amended. I'm the one that contacted him and said, you're missing significant portions of this document. But in any event, Judge, the site plan, we're going to find out. I'm 100% confident that the court's going to find out that there are 3 easements in this case. It's on the site plan. Malachi overlays the Adams Road. They lay on top of each other. He references it in his initial complaint. I believe he talks about Adams Road. He then talks about Malachi. He knows Malachi is 40 feet in width. How does he know that? He didn't attach that to the complaint. Broody Lane is 33 feet wide. So those easements are being litigated by the court. You're being asked to quiet title to all 3 easements. If you look at the Savoy case, you can't do it unilaterally and only as to this particular defendant. All of them. If you had a permanent injunction finding that there's no commercial vehicles permitted, then the next defendant says, what? I have a tree cutting business. I have a snow plowing business. How are they not going to be bound by that? They have to be joined. If he wants to back that relief out and simply go on nuisance or really get to the issue of the contractor's yard, that'd be sufficient. But our motion cites 2205. I cite a case in which they did not join the necessary parties. That's the Meyer case. And when they didn't, the case was dismissed. Now, the plaintiff may have gone back and added those parties, but it's not frivolous because of the relief that he seeks in this case. And we're going to end up right back here on those 3 easements. And he either has to amend his complaint again and eradicate that relief for quiet title, or simply just go with the nuisance claim on the contractor's yard.
All right, thank you. The defendants have filed a motion for summary disposition under MCR 2.116 C7. There's been no argument in the 1.5 page brief or in the oral argument today how that would apply. So that motion is denied. Defendants have filed a motion for summary disposition under 2.116 C8 for failing to state a claim on which relief can be granted. There's a count for trespass for removal of trees. There's a count for trespass interfering with their property. There's a count for nuisance based on their behaviors. There's been no argument either in the brief or today about those counts. And the quiet title action, the complaint, the argument from the defendant is that plaintiff hasn't joined all necessary parties. Plaintiff says, well, we don't need those parties. We're only wanting to enjoin one party's overburdening of the easement. I've seen no authority for why that's not permitted.
The hammer drops. The judge denies the motion to dismiss, essentially telling the defense their paperwork arguments didn't hold water. But the real mic drop happens at the very end. The judge admits she doesn't know this attorney's practice, which is a polite way of saying, I'm watching you. Final takeaway: in law, technicalities matter, but they rarely trump the actual facts of the case. The contractor's yard dispute lives to see it.
That motion is denied. The motion also says C10, but that's not even contained in the brief. It's not argued today, and that would be premature in any event. There'd have to be some showing that even absent discovery, they can't win. That motion's denied. Mr. Delaney, I think this may be the first time you've appeared in front of me, so I don't know you. I don't know the nature of your practice. I got to tell you, this is on the border for assessing sanctions. This is if I see pleadings from you like this motion for summary disposition further in this case, I will assess sanctions. I'm not going to do it today, Mr. Talganoff. Mr. Talganoff has made some excellent points about that. This is not a court where you can file a 1.5-page motion that barely even gets into the grounds for relief and expect to get anywhere. That's not how I do business. And I expect it's not how you're going to do business in front of me. Your motion for summary disposition is denied. And I'm going to ask you to submit an order so that Mr. Talganoff doesn't have to bill his client for preparing an order. Now that leaves us with the contempt issue, the scope of the TRO, whether there should be preliminary injunction. It does seem to me that we need to schedule some time. And despite the saber rattling on both sides, you might not be as far away as I thought when I'm reading this. So how much time do you think you would need to get through all this? A half a day would do it, right?
I think so, Your Honor.
Well, the court has, the plaintiff requested criminal contempt.
Well, they just checked. I checked that box, which frankly, I probably should have checked them both, because criminal contempt is not, it's a quasi-criminal proceeding. A criminal contempt is to punish past violations. Civil is to kind of coerce to stop ongoing ones. And frankly, it was probably an oversight. I should have checked them both. But in any event, we're in the criminal contempt world for punishing previous violations. But
and because of that, and I recognize I made a jury demand. But
there's no jury trial for contempt.
Well, on serious criminal contempt there is. But
You want to be careful. I just cautioned you about frivolous things. And this was the most frivolous thing in the case. Because you said criminal contempt is punishable by 30 days. Wrong. It's 93.
okay,
You said he's entitled to a jury trial. Wrong. The U.S. Supreme Court case that you cited says only if it's 180 days. So stop telling me untrue things, Mr. Delaney. I do not countenance that well when attorneys do that. No jury demand. There's no jury trial right for contempt under Michigan law. That is well established by Michigan and U.S. Supreme Court authority.
does the criminal contempt portion then stay in place in any event? I just want to discern from the court, because that'll dictate the amount of time I would want to allocate. I think I'll need a full day. And to the court's point a moment ago, I'm advocating for my client, not attempting to challenge the court. The criminal contempt citations are rare for me and real estate cases, but in any event, if the court, if I may inquire, is going to put it all on the table as far as dissolution of the TRO, the scope, all those types of things of the easement into the contempt hearing, then I think I might need as much as a day if the court thinks that's reasonable, but only if the court is going to put everything in that same box. If the court follows my...
Well, you have a motion to dissolve the TRO. There's a motion for preliminary injunction. And so that's all kind of together. And in terms of the contempt, I mean, really, I don't know. I mean, Mr. Talganoff, where you're at on that, that was an error or oversight on my part to not check them both. The criminal contempt is only checked to punish past conduct. But really, I think there's already trespass counts in the complaint for that. In terms of enforcement of the court order, civil contempt would probably do the trick. So unless there's some objection for Mr. Talganoff, I mean, I would, if the parties allow, consider that amended, and I can submit I can submit on my own an order indicating that it's being amended from a show cause for criminal contempt to civil contempt.
I think that's fine. I don't think you were probably going to throw Mr. Hope in jail for this, so that's fine.
Okay. It appears I'm getting closer to that. If the court doesn't mind.
No.
And the final issue would be the definitions in the court's TRO. Do we include that also? They're not defined, they're stated. And so I'm just trying to control the court's time, if I will.
So I'm not sure I understand your request.
Yeah, in other words, my client would be appearing on a show cause for whether or not he used cars and non-commercial trucks for residential purposes. I would be going into a hearing not knowing those precise definitions. And if you had an opportunity to go through Savoy, they struggled with it too. And so I would be going in not knowing what those words mean and whether he knew. And I don't want to add that to the hearing, and we're trying to call witnesses and definitions. But again, contempt hearings in real estate cases are new to me, and I just want to not come back and retest the court as you've made that clear this morning.
Well, listen, my comments are not intended to prevent you from advocating zealously for your clients. I hope I've gained a reputation of wanting to allow that sort of thing. I just want you to dot your I's and cross your T's as you do it.
Sure.
So you should not feel hindered at all by my admonishments today.
And on that issue, Judge, on the definitions, what's the court's thought about that? And
I'm not going to define them on the record today without hearing from the parties.
Okay.
The order says what it says, and parties wanting to argue about what the meaning of an order was is always within the proper scope of argument.
Okay. At the show cause hearing.
Sure.
Okay, thank you. Thank you for that clarification, Judge, so that I can dot the I's and cross the T's as you indicate.
All right, so I don't have a courtroom right now, so I'm borrowing courtrooms. So I guess I'm going to ask, I'm going to continue the contempt. I'm going to adjust it to civil contempt, and I'll enter an order. I'll expect to see an order from Mr. Delaney denying his motion for civil disposition. And we'll continue the motion to dissolve the TRO and for preliminary injunction to a date and time set by the court for a full day to allow evidentiary testimony. Do we need to have some timetable where you exchange witness and exhibit lists? I mean, that basically turns into the trial of the case. Or can we just set a day, and you guys spring with the brain, and we will?
I'd like to see a witness list so that we're prepared. I don't know what counsel had intended for this. And while we're on that subject, if counsel and I could work together on our schedules, if the court sets it, then I might have a
Why
job.
don't you guys talk?
Okay.
I'll say 7 days for witness list.
Pardon me, 7 days per witnesses? Sure.
Yeah.
7 days for your witness list?
Yes. And
then if you guys talk, and then contact my assignment clerk,
Okay.
and if necessary, we'll have to schedule a phone conference for the three of us to talk off the record, because I need to find not only a date that works in my calendar, but yours, but a date when I can find a quote.
Sure.
And in the meantime, the TRO will remain effective.
Okay. Could we also ask about the answer?
Oh, yeah.
Because there is
Now
that.
the motion has been denied. An answer to the amendment complaint has to be filed.
I think it's 21 days.
I think so, whatever the court rule is about that. And
Okay.
I didn't perceive that your filing of a motion to be somehow gamesmanship or improper for that. It's a responsive pleading under the court rules. So we said answer, but a motion for summary disposition is a responsive pleading under the court rules. I didn't find it.
Okay. So 21 days from today, I'm just trying to get.
That's fine.
Okay.
Yeah.
It'll be sooner than that. And then I'm still concerned about the half day. I think we're going to
We'll
go.
do a full.
We can do a full day.
Okay,
Yeah.
very good. Judge, thank you for your time. I appreciate it. And the court has a
Thank you, Your Honor.
reputation for fairness. There's no question about that.
All right, you guys have.
Thank you.